Hi, folks. Mark your calendars. We have a new date for Donna Adelson's trial. The final pretrial hearing will take place on August 8th at 9 a.m. in courtroom 3G. That's the courtroom we like. Jury selection will commence on Tuesday, August 19th at 8:30 a.m. in courtroom 3G. The court said that it anticipates that jury selection will conclude on or before that Friday, August 22nd, 2025. Opening statements and testimony will begin on or before Monday, August 25th. The court also indicated in the order that no further delay shall be granted without good cause. So in the end, this wasn't a huge delay. One additional update. There will be a hearing on Friday, May 9th at 9 a.m. on Donna's motion to take additional depositions. That hearing will also be here. It's likely concerning the taking of depositions pertinent to the recently concluded investigation, which included at least one wiretap and obtaining financial records from Harvey Adelson. The next case management conference is set for June 11, and it will be right here on Deep Dive True Crime. We may also upload it to ML Justice Network. Amended order setting court proceeding dates and procedures. On Wednesday, April 30th, 2025, this court held a hearing on the defendant's expedited motion to continue trial. Based on the continuance of the June 3rd, 2025 trial date, the court sets the following proceeding dates and procedures. A. Discovery deadline. The court expects that all discovery, including depositions, retention of experts, and disclosure of witnesses or materials in compliance with Florida Rule of Criminal Procedure 3.220, will be complete by both parties on or before Friday, May 30th, 2025. The court recognizes the continuing duty to disclose, particularly if records custodians change. Leave of court may be sought if necessary related to the state's recently completed investigation. B. Pretrial motion filing deadline. All pretrial motions must be filed on or before Friday, May 30th, 2025. The court expects that both parties will promptly file all motions that were previously due on April 30th, 2025, and confer on matters that do not require hearings. Any pending motions in limine will be set for hearing promptly, but at the latest in June 2025. Parties must provide the court with a courtesy copy of all filed pretrial motions at the time of filing. And C, witness list, exhibit list, and demonstrative exhibits. The state and defense must provide the final witness list, final exhibit list, and final list of demonstrative exhibits to opposing counsel, with courtesy copy to the court, on or before Friday, May 30th, 2025. We have 2 paid interns who will be working on the channel this summer, and we plan to bring you high-quality content, not only about this case, but about many other cases as well, including cases that no one else covers. I'm Ed, not AI, Deep Dive, True Crime. Okay, let's get into the insights. First, given what the prosecutor revealed during the hearing, it seems that the new investigation was started by a tip by a jail informant, and that the tip concerned witness tampering, possibly involving Harvey Adelson. It seems that the investigation may have targeted defense counsel as well, given how defensive the defense attorneys were at the hearing, where they complained that prosecutors were not responding to their inquiry about whether their private conferences with Donna at the jail were being recorded. Sarah Dugan quickly got up and said that did not happen. She also revealed that none of the new recorded calls included conversations between Donna's lawyers and Donna. The defense mentioned the fiduciary privilege. Thus, we anticipate that members of the defense team were recorded in conversations with Harvey Adelson, and that the defense will claim that those conversations were privileged as well. We anticipate that the prosecutors will counter-argue that such communications are not privileged, or that, if privileged, the crime-fraud exception may apply. These are educated guesses, of course. We will continue our analysis as more information is revealed. It seems pretty certain that the investigation was focused primarily on Harvey Adelson sending funds to someone via Zelle or other methods. The state announced it has Harvey's Zelle records. We would not be surprised if the wiretap was on Harvey's phone only, although there remains a possibility that the lawyers' phones were also tapped. Seems pretty clear that Judge Everett must have signed off on the warrants, and this may be the reason why the defense wants Judge Everett disqualified and filed a petition for writ of prohibition, asking the First District Court of Appeal to grant the petition and find that Judge Everett should have granted the defense motions, original and amended, to disqualify Judge Everett. With all these developments, including a pending petition for writ of prohibition, a continuance makes sense. On top of that, if the appellate court agrees with the defense's arguments and a new judge is appointed, the defense will have the opportunity to re-argue several of the motions it had mostly with Judge Everett. We're looking forward to see the records that are about to be unsealed and whatever else becomes available about this new investigation. We are particularly curious about who was the tipster and who was the target in the jail. From our recollection, the two ladies from the jail who had given favorable information to Donna about Catherine Magbanua were already out of jail by the time this new investigation started. So perhaps one or more returned to jail, or someone else was supposedly helping Donna. We should know soon. Of course, the defense attorneys were quick to point out that the tip was deemed to be false, but no details were given. The prosecutor confirmed that some of the evidence developed will be used at trial. If the original tip involved accusations of involvement by the defense lawyers, that may explain why they are acting so defensively. Maybe the tip was false as to their involvement. Again, we don't have all of the details, so this is educated guesswork. There are more clues about the fact that the investigation, if it involved the lawyers directly, did not find any wrongdoing on their part. Had the evidence shown anything illegal being done by the lawyers, the prosecutors would have moved to remove the lawyers from the case due to conflict of interest. Sarah Dugan also confirmed that she is not aware of any new charges being brought based on the additional investigation. She only mentioned the development of evidence that will be used at Donna's trial. A crazy case is getting crazier by the day. Meanwhile, Donna sits in the Leon County Jail, Harvey sits at home, and Wendy must be fearing the day when the knock comes on her door and this crazy saga continues toward its end. Justice for Dan Markel, his children, and family.
For Judge Jackie Fulford, on behalf of Ms. Adelson, our position is that the information that's contained in the items that Your Honor is referring to would need to be referred to also in the arguing of these motions. And we're here in open court, and I'm not sure how we protect the sealing of those documents when we're going to have to argue the very materials that serve the basis of why we're here asking for a continuance and a motion to compel.
Is anyone actually getting into the warrants or the affidavits themselves with what you plan to argue?
Yes, Judge, and the materials from the investigation.
You have those to actually bring up as a part of your argument today?
Yes, Judge.
Not generally, not just referencing them, but the actual materials from the warrants and the affidavits.
Well, there need to be statements put on the record on behalf of Mrs. Adelson regarding what was claimed to have happened in the investigation that has since proven to be false, that has not been retracted by the state. And in making those arguments is part of the basis for why we need a continuance and why we're asking for the relief in the motion to compel, as well as additional depositions.
To that end, Ms. Dugan, is the state planning to file any superseding indictment or any additional charges based on the investigation that is now concluded, or at least is alleged to have concluded?
No, sir, not to my knowledge.
With that being said, if the defense is seeking to file any motions related to these matters, they are not related to pending counts. However, you can pursue them as you believe them to be appropriate. As to the warrants and the applications, does the state have a position as to whether they should remain sealed or any documents referencing them should remain sealed without redaction?
No, sir. We would defer to the court. And some of the discovery the defense has moved to compel is sealed, or a lot of it is. And I actually brought a motion to unseal the documents and recordings related to that today so that those can be provided to the defense. But maybe for the limited purpose of discovery, but whatever the court prefers, we don't have a position.
Your Honor, the expedited motion to continue that was filed on April 21st. I try to make my arguments as clear as possible in the written pleadings. What has come out about 3 weeks ago is the state conducted this additional investigation into allegations. As part of that, they obtained additional records. We also learned approximately 2 weeks ago during Investigator Newland's deposition that the state had not given us materials that had been given to prior counsel. So we've been asked to trust without the ability to verify. And in fact, months ago, I asked the state for a list of the materials, everything that they had, everything that Corbett had, so that we knew if we had received everything. And they did not provide that to us. So now we have received it from the materials we received over the last few weeks. It appears to be over 100,000 emails. We have purchased 3 pieces of software in addition to the software that we used previously, trying to...
Is this to sort through or sift the emails?
Some of it's to open it, some of it's to sort through. Yes, Your Honor.
Go ahead.
None of them are very effective at doing that. So we've actually engaged a e-discovery platform to assist us, but that hasn't even been set up yet. That was a decision that we made last night after trying the additional piece of software yesterday. In addition to that, we have new cell write extractions from Mrs. Adelson's phone. I understand in the state's response to the motion to continue that they don't intend to use any of that, but that doesn't mean that there's not something in there that we want to use.
And I did want clarification on that point. As to the discovery provided to prior counsel, Ms. Dugan, the response of the state is that on October 31st and November 8th, the raw data from the defendant's phone and email accounts were provided. Is that correct? Is that what your response is getting to?
Is this concerning? Can you tell me
Just the raw data from the defendant's phone and email accounts?
Yes, sir. Those have all been previously provided. I thought he was talking about the 100.
We're going to get to the filter team documents. The best way to do this, take it into bite-sized pieces so it's clear what is being argued, what is not.
Yes, sir. So it's my understanding that all of Mrs. Adelson's phone records were previously provided in November 2024. There were certain phone records, I believe it was 7 pages of phone records that were actually, this is going to be paragraph 7 of the defense's reply to the response. These are phone records that Donna Adelson's prior defense counsel had an issue with us not having. So these were subpoenaed. TPD received them in October of 2024. This state attorney's office didn't know TPD had received them. TPD didn't know that we didn't have them. And so that's why they weren't disclosed. But ultimately, they have now been sent to. Ultimately, though.
Go ahead.
Yes, sir. I'm told it's 7 pages of records. So those were the 7 pages that they did not have that weren't disclosed to them last fall. That's my understanding. And we would object to a continuance based on those pages.
Until it was after, if Your Honor recalls, during the expedited hearing that we had a couple of weeks ago by telephone with the state and defense on the phone. Those were the records that we were addressing then, and I believe that we got those. April 10th, 2025. And that's, the state actually acknowledges that in their response.
Mr. Velman, you're not going to make your argument for you, but ultimately you believe you need to review these to be prepared for trial itself.
Yes, and those aren't the only issues that have arisen over the last few weeks. The motion details the additional issues. But needless to say, we have spent the last 3 weeks trying to collect this material, some of which we still don't have.
You're referring to the recent investigation.
Yes.
Go ahead.
And even if the state isn't going to use the information, we still need to know the extent to which they violated, they intercepted and monitored attorney-client communications and communications that are protected by the fiduciary client privilege. We don't have all of that information yet, and they have not responded. As indicated in my reply yesterday, the state hasn't responded to those emails requesting that information.
Ms. Dugan,
Yes, sir.
concerning the aspect of the recent investigation, which materials are yet to be provided and why?
Yes, sir. May I also address the 100,000 emails?
Go ahead.
Okay. So those 100,000 emails are redacted privileged communications that the defense recently received that occurred between the Adelsons and prior counsel. This communication was redacted by a taint team. It's never been seen by the prosecution.
The filter team document
Yes,
you're
sir.
referring
Thank you.
to.
Filter team. It's never been seen by the prosecution. It's obviously privileged. We obviously do not intend to use it in our case, having never seen it. And I also can't imagine a scenario where the defense would be using it in their case. I would feel like all of that information would be hearsay and self-serving hearsay. So the state is objecting to a continuance based on their needing to review all of the privileged communications with prior counsel.
When were the filter team documents provided?
They were provided on April 10th during, one second, I want to double check. During Jason Newland's deposition by this defense team. Somehow some question was asked where he referred to the filter team that the court referenced. And this defense team was not aware that the filter team had gone through all of those emails and kept all of the privileged emails from the prosecution team and provided them to former defense counsel. So those were then provided to this defense team.
Very well.
And Your Honor, I could address that very briefly. Judge, advice of counsel is something that would be relevant. It goes to Mrs. Adelson's state of mind. And if there are any emails in the records that we received 2 weeks ago that would rise to that level, then it would absolutely be relevant and admissible if it goes to her state of mind concerning, for example, her leaving the country.
Back to the recent investigation discovery, Ms. Dugan, the items that have not been provided, I believe some of these pertain to the parameters in the Title III that were supposed to operate as safeguards. Is there a reason this has not been provided to the defense?
So looking at the reply and the motion to compel, all of those, the things that they're requesting here as far as the minimization instructions, all the logs, all of those things, I feel once the order to unseal has been signed, those can't all be disclosed. The only thing that I saw that would be additional that they are asking for is surveillance video, which is surveillance video from the jail, which I've been told has already been disclosed to the defense. They also asked for the financial records that are mentioned in the application. I was told that we subpoenaed Harvey Adelson's Zelle account. I found that those Zelle records and had it sent to the defense this afternoon. So once those items are unsealed and they can be disclosed to the defense, that should be all of the discovery that pertains to the wire.
Please provide the order. Has the defense been able to take a look at it?
No, sir.
The memorandum that he authored indicated that the wire went down February 24th. Ms. Dugan is telling me that the wire actually went down February 21st. So if we can just make sure that that's accurate.
Yes, this is one of the paragraphs in the defense's reply. That was just a mistake on the memo. The wire came down on the 21st. I believe the significance of the 24th was when the order was signed, and I think Mr. Newland's memo said the 24th, but it is the 21st, which is reflected in the order the court's looking at now.
All right. Court will sign the order at this time. I believe that deals with your motion to compel, Mr. Zellman.
May I address one more thing about the issue we were just talking about? There is obviously this new discovery from this lead that the state was alerted to last fall. We conducted this investigation and followed that investigation to its conclusion. That obviously has resulted in some new discovery in these wire calls. But I did want to let the court know, though there are a large number of calls that the defense, of course, wants to review, there are only, I was told, about 30-something calls deemed pertinent by law enforcement, and the state likely plans to only use maybe one or two at trial, and believes that the 2 months the defense had from the time it was discovered to the time of trial in June should be sufficient to prepare for that portion of the trial.
Do any of the calls that you intend to use from this recent investigation go to privileged matters or encapsulate calls with counsel?
Thank you. I wanted to address that. There are no calls that were recorded between the defendant, Donna Adelson, and attorneys in this case. I specifically asked the investigator about that before the hearing.
The state has also not responded to our request to let us know if they've also been monitoring our attorney-client conferences at the Leon County Detention Center.
That's a no.
And although the state believes that we're going to have enough time, I calculated this. There are over 32 hours of calls that were captured on that wire. And given the amount of materials that we have just been handed, we have not had an opportunity to review even 2 hours of those calls up to this point. Your Honor, just because the state believes that there's going to be enough time for us to prepare, and it's not 2 months, it's more like 6 weeks. There's not enough time for us to to analyze this new information, synthesize it, prepare appropriate motions. We've spent the last 3 weeks dealing with this as opposed to finalizing the motions in limine.
That is an important point you bring up. Essentially, between what has been recently investigated and what the charges have been of murder, solicitation, and conspiracy from the time your client is charged, there are essentially two different pots, if you will. For the motions that the deadline was today as to murder, solicitation, and also the last count as well, are those motions completed?
No, Your Honor, we've only had an opportunity to finish 2 additional motions that have not yet been filed. And I have not had an opportunity, because we had to adjourn Investigator Newland's deposition, to finish the Frank's motion.
Right? So you are, in fact, asking for an extension on the deadline to file your motions.
We're going to need one in addition to the continuance. Yes, Your Honor.
Ms. Dugan?
If the court wants to give an extended motion deadline, we don't have any objection to that. We do object to a continuance of the trial and remain ready for trial.
What is the defense? Well, before I come back to you, Mr. Zellman, what is the prejudice that the state would suffer if the trial is continued, Ms. Dugan?
We would not.
Beyond just a mere objection.
We would not suffer prejudice, Judge. We're just ready for trial if it goes as continued.
Mr. Zellman, what would you be proposing as a date? And you also have to keep in mind there's only so many points in the year a trial that could take either 3 weeks or more can be scheduled. And I assume you've discussed with your client if your relief is granted.
We have.
What that means.
We have, Your Honor. And frankly, without getting through all of this new material, it's hard for us to pinpoint exactly when. I mean, we're not going to sit around on our hands and do nothing. We have been diligently preparing, and we're going to continue to diligently prepare. Likely 2 to 3 months would be, I think, realistic. But again, until we get through all these new materials, it's going to be hard for me to say.
As always, we'll keep an eye on the case and we'll bring you updates about any developments. I'm Ed, not AI, Deep Dive True Crime.